Hey guys, and welcome to today's video. Today, we have a few cases to cover, starting with a dangerous defendant in Michigan who doesn't understand what the judge means when she says he's not allowed to be around the victim of a DV that he is accused of committing. Sorry for the interjection, but post-editor Skeptic here. I found a video yesterday that I've added to the end of this video from Judge O'Donnell's courtroom that was pretty wild and crazy. I'm not going to ruin it for you, but here's a clip.
I'm not saying I didn't do it.
You don't expect me to buy that line of bull, do you?
Do
You really?
But first, we're going to start with probably the most ridiculous thing I've ever seen at the appellate level, an AI-generated avatar posing as a lawyer. We're going to start with the artificial intelligence, which is probably half as intelligent as you and I, and twice as intelligent as the dipshit he's defending. So let's begin.
DeWalt versus Mass Mutual is being called out of turn, and the appellant has submitted a video for his argument. Okay, we will hear that video now.
May it please the court. I come here today a humble pro se
All right.
before a panel of 5 distinguished justices.
Is this, hold on, is that counsel for the case?
I generated that.
I'm sorry?
I generated that? That is not a real person.
Okay, it would have been nice to know that when you made your application. You did not tell me that, sir. I received the application. And you have appeared before this court and been able to testify verbally in the past. You have gone to my clerk's office and held verbal conversations with our staff for over 30 minutes. Okay? I don't appreciate being misled. So either you are suffering from an ailment that prevents you from being able to articulate, or you don't. You are not going to use this courtroom as a launch for your business, sir. So if you are able to shut that off. If you want to have oral argument time, you may stand up and give it to me. You have 5 minutes.
Yeah, using AI to not just write your appellate brief, but also to present it for you has to be one of the stupidest things I've ever seen anyone do. Now don't get me wrong, I love using AI, especially to help research relevant laws and court rules in my videos, and today's sponsor, Venice AI, has definitely helped me streamline this process. Did you know that the CEO and co-founder of ChatGPT, Sam Altman, recently announced that ChatGPT can now reference all your past conversations? And let's top all of that off with OpenAI considering forcing you to have a government ID just to use their services. So in a world where Alexa listens to us constantly and Facebook retargets us based on our browsing history, do you really think that ChatGPT is going to respect your privacy? Let me offer you something else instead. Venice AI. Venice AI utilizes leading open source AI models to deliver text, code, and image generation directly to your browser without any need for any downloads or installations of anything. Messages are encrypted and your conversation history is stored locally in your browser. I'm actually a proponent of AI, but I also believe that we shouldn't have to give up our privacy just to use it. And their Pro plan unlocks a full platform and features, including PDF uploads for summaries or insights, the ability to turn off safe mode for unhindered image generation, and the ability to change how Venice interacts with you by modifying the system prompt alongside limitless text and high image generation limits. Try asking DeepSeek, the Chinese competitor to ChatGPT, to criticize Xi Jinping. Due to that infamous Chinese censorship, you simply won't get an answer. Now look what happens when I ask Venice AI to give me those same materials. Boom. Just like that. The censorship-free request I was looking for delivered directly to my web browser. And one of the best parts about Venice AI is that you don't even need an account to try it out. Just head to venice.ai/Team Skeptic and start chatting privately without fear of handing over your most intimate thoughts to a corporation or the government. And if you use code Team Skeptic at checkout, you'll receive a 20% discount on their Pro plan. Now, I highly recommend that you give this a try, and thank you once again to Venice AI for sponsoring this video. Now let's head to that Michigan case, where the defendant refuses to use his right to remain silent and ends up talking himself into a high cash bond and probably more criminal charges.
All right, I'm Magistrate Garwood. I'm going to be handling your case today. I'm told that you did not want to speak with the public defender.
No.
So, in this circumstance, at arraignment, everyone has the right to have counsel present to assist them for your first court appearance.
Okay, that's why I didn't need anyone to defend me, because it's my first court appearance, because there hasn't been any problems.
Okay, but it's your first court appearance, and today the court's going to advise you of your rights. I
Okay.
am going to go through the charges with you so you understand what you've been charged with. I'll give you your next court date. I would appoint counsel if that's something you would like the court to do. That would be at little to no expense to you. And then I have to decide what to do as far as bond and bond conditions. Conditions are things the court tells you you can and cannot do. If you violate a condition, you're subject to immediate arrest. The amount of your bond, that's when you have to post something in order to be released. That's an evaluation I'm going to be making today.
Okay.
So are you sure you don't want to talk to Ms. Anderson? She's an attorney. She's been an attorney for a really long time. I'm guessing you're not an attorney.
No, I didn't break any laws, and I've never heard.
Well, you've been charged.
I've
You've
been charged falsely, though. I have already called the police several times and explained this whole situation. Just like Haniel has called the police and explained that I look like her ex that hit her.
Okay, so here's the thing. First, I'll advise you of your rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. So you're going to want to be careful about what comments you make. Second, you have the right to an attorney. If you can't afford an attorney, the court will refer you to the local appointing authority. In that circumstance, Ms. Anderson would assist you today, and then the public defender would be able to assist you going forward. You also have the right to a trial. At a trial, a jury or a judge would be able to decide whether you're guilty or innocent. This is case YPD 25-6642. So would you like to reconsider and speak with Ms. Anderson?
Before I make a decision, is whatever I choose, is it going to be a reason for me not to be able to go home and get out today? I understand whether I want an attorney or not.
An attorney is not going to hurt you at this point. An attorney is going to help you at this point because they understand the law and they understand the right arguments to be making regarding bond. I can tell you the prosecutors are requesting a cash bond. So they're requesting that you have to post $25,000 to be released from jail. So it's probably going to help you if you talk to the public defender. If you don't want to, I can't force you to talk to her, but she's here.
And if I don't, then I won't be able to get out without a $25,000 bond.
Well, you'll have to make your best arguments on why I should release you.
Okay.
So what do you want to do?
I'll say what I can say for it to be released. I don't need somebody else to say it for me. I mean, I know the law too.
You know the law?
Yeah, I'm not a lawyer, but I went to high school.
You and every other lawyer out there. The only difference between you two is like 6 additional years of higher education, 6 gallons of consumed lead paint, and 6 flights of stairs that you were dropped down head first as a baby. Other than that, you guys are essentially twins.
Okay. All right. So I've advised you of your rights. The complaint in this matter alleges that on or about May 24th of 2025, that you were at 201 North Huron Street in Ypsilanti. The single charge alleges that you did make an assault or an assault and battery upon Hanel Groshusch, Grosshusech, an individual with whom you've had a dating relationship. That is a misdemeanor charge. It carries a maximum penalty, 93 days in jail and or $500. Do you understand what you've been charged with?
No, because this charge is false. It's not.
Okay, hold on.
Correct
That's
charge.
something
I never put
different.
my hands on
Hold
it.
on. That's disagreeing with the charge. Do you understand what you've been charged with? I understand you're saying you're innocent. It wasn't you. You didn't do it.
Okay.
But for today's purposes, you've been charged with this crime. So do you understand what that crime is? Or do you need me to
Yeah,
go
I
back through it?
understand what you said, but I'm just saying it's false.
That's fine. So you understand what you've been charged with. Do you understand the maximum penalty?
Yes.
All right. I'm going to have you stand mute. That means you'll remain silent as to the charge. I'll enter a plea of not guilty on your behalf. I'm going to schedule you for your next court date. That's going to be a pretrial that will be in person in front of Judge Barr. He will be able to see you on June 5th at 9 a.m. at the 14A2 District Court. We
Well,
will send.
I have,
Yes.
the problem is I still have 4 daughters and bills to pay. I need to be able to go to work. How am I gonna?
We're not there yet. I'm just giving you your court date.
Okay.
Okay, so in person at the 14A2 District Court, June 5th at 9 a.m. in front of Judge Barr. We'll send you a notice to appear at the jail. The next thing we'll need to address is bond. There are two parts to bond. Bond conditions, those are things the court tells you you can and cannot do. If you violate a condition, you're subject to immediate arrest. The other side of bond is whether you can be released today on your own or whether you'd have to post a bond in order to be released. Before I make any decisions regarding bond or bond conditions, I will hear from Ms. Londi, who I think you still need to put your appearance on the record. And then I'll be happy to hear from you. But again, I want to remind you, anything you say can be used against you and you do have the right to remain silent. Ms. Londi, your bond arguments?
Thank you, Your Honor. Ashley Londi for the people in this case. Your Honor, has the court had the opportunity the court took a swear to in this case, correct?
Yes, we did that this morning.
Thank you. Your Honor, I am requesting a cashier surety bond. I am also further, I believe, requesting a GPS. I have to pull up my notes here. In this case, the allegations include the defendant remaining in the victim's home, not leaving when being asked to leave, going into her bed and touching her under her clothes. The victim did not provide additional details for us to be able to look at charging a CSC in the 4th degree. However, there is sufficient evidence to charge the domestic violence as they had previously been in a domestic relationship, a dating relationship. So I am requesting a $25,000 surety bond as well as a GPS tether to keep him out of that 201 North Huron Street.
There has never been.
Sir, you do not get to interrupt me.
It is not your turn to talk, and
Oh.
you're not going to interrupt anybody.
Sorry.
Ms.
So
Lund.
I'm extremely concerned for her safety. This is a very disturbing fact pattern and a disturbing case. I'm also requesting that there be a prohibition against the defendant possessing firearms as a component of his bond, as well as standard supervision at community corrections. And that $25,000 cashier surety bond, I'd request it be no 10%.
At first, when I heard the recommendation of $25,000 cash or surety with no eligibility for a 10% bond, I thought it was kind of harsh. But then he got his opportunity to speak, and I wondered if even that was enough.
All right, now, sir, you will be able to make your bond arguments. But again, I want to remind you, anything you say can be used against you.
Okay, I have permission to speak now.
You do.
But okay, so what I'm saying is, me and Haniel have never been in any sort of violence whatsoever, not even one time. And she's called the officers before and explained that has nothing to do with me. So because I don't understand why is all this necessary? Because the last time I called the cops and had a welfare check done on her because she wasn't answering, I was worried about her, and the cops came and arrested her. So, why is all this information just gone? Nobody knows, understands. They're not helping. They just come and try to accuse us of hurting each other, but it's others that's hurting us and taking from us.
So you do have a criminal history. I mean,
No, no, I don't.
what's your date of birth?
No criminal history.
So you pled guilty to an assault and battery.
Yeah, because they said I was gonna be, I have kids and house payments and responsibilities to take care of my family. And how am I supposed to do that being in jail for months to be able to just go on
Pled
trial?
guilty to attempting to assault, resist, or obstruct a police officer.
Yeah, I know, I had to, because I didn't need to be in jail where I can't even take care of my family. That's the reason.
Well, regardless of why you did that, you have a criminal history. That's just the fact of it.
I would never hit a woman anyways.
You-
I never said I wouldn't leave. But I said I was leaving. She's told me not to leave until you guys got there, so she knows I'll leave because other people that she's been with, because she dated several guys that look like me, because that's who's just her preference, I guess. But even I've never told her I would not leave. I would not do that. I don't want to be somewhere I'm not wanted. You know, she wanted me to come there. I said I can't stay here. You know,
I would encourage you to stop talking. Because now you're talking about what allegedly took place on that day. If you can keep talking, but you may make the prosecutor's case for them by saying what you're saying.
I told her that I can't stay until until the police come, because even if I do, they're just gonna arrest me because you already know that I'm not supposed to be here. How is she gonna? I only went there to give her money. I gave her money when I went there.
Pay attention, my friends, as he's about to put on a masterclass on why you should let a lawyer speak for you and why you should enjoy your right to shut the fuck up.
Okay, so now you've acknowledged that you were actually at the property. So again, I'm going to encourage you to stop talking. Is there anything else you want to say before I proceed with your bond conditions and bond amount?
No, that's all. I was saying, you know, I'm sorry. She probably was just having a bad day. You know, it's not. I would never hurt her. I love her. I love her with all my heart. I care about her.
Okay.
If she's sick, I go get her medicine or ask her if she wants something that would make her feel better. Or say I'll get whatever she needs to be happy or
Okay.
feel
I'm
comforted.
going to have you stop talking because again, you are saying things that I do not think are going to help you in this case. Your bond conditions are as follows. You're going to be required to have standard supervision at our community corrections department that will include drug and alcohol testing. Each time that you are required to test, you'll have to bring photo ID and $12. If you don't have photo ID, then you'll be able to ask the jail for a copy of your booking photos. No alcohol, no illegal drugs, and no marijuana. Do not leave the state without prior permission of the court. Do not purchase or possess any firearms, ammunition, gun components, or any dangerous weapons, nor are you to be with anyone who has any of those items. Do you own any of those types of items?
No.
Do you understand your conditions so far?
Yes, but am I allowed to say anything else?
I'm not done.
Oh, okay.
Do not assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. Do you understand?
Yes.
You're to have no contact with, when I say no contact, no direct or indirect contact with her, no telephone, email, texting, internet, or social media, Skype, Zoom, FaceTime, Facebook, Slack, Discord, Instagram, Snapchat, TikTok. No contact means no contact. Don't direct anyone else to be in touch with her on your behalf. Don't mail anything to her. Don't deliver anything to her. Don't have anyone else do what you're not allowed to do in reference to contact with her. Do you understand?
Yes, of course.
You are not to go to Huron in Ypsilanti. If that is your home address, you must find another place to live and you must notify the court of your new address within 24 hours of your release from jail. We will give you a phone number that you can contact. If you need to return to that address for a civil standby, you'll be allowed to do that. A civil standby allows you to contact the police. They would meet you there. They are there to keep the peace. That is not an opportunity for you to hang out. That's not an opportunity for you to communicate with Hanel. That's just an opportunity for you to get your things and go. Do not go without the police. Do not
Okay.
go to any home, temporary residence, work, school, or house of worship of. Do you understand?
Yes.
Do not violate any criminal law. You're required to appear for any and all court hearings and other places as directed by the court. All of your conditions, they will exist whether you're in custody or out of custody, and they'll remain in full force and effect until changed by the court. If there's any change to your address, email, or telephone number, you're required to notify the court. If at some point you change your mind and decide you want the public defender to assist you, you would make the judge aware of that, and then the judge can make a referral. Do you understand?
Yes, ma'am.
Do you have any questions regarding your conditions before I set the bond amount?
No, can I say one more thing?
I don't think I could stop you.
Okay, so I just want to know, so as long as I don't go there, even if she tells me to go, so that there won't be no problems between us?
Dude, you do not get it. Do not go over there under any circumstances, and there won't be any problems between you two. In situations like these, the courts must do what they can to protect the victim, which means until all of this is settled, you're not allowed to contact her via any means, or you're going to end up back in jail. Not that you're going to get that opportunity, as you just admitted to several crimes alongside verbally admitting to either intentionally or unintentionally being ignorant when it comes to following court orders.
You can't have contact with her. It's not
No,
just.
I know, I understand, but
Yes.
she's the one that called me to ask me if I'm okay.
Again, I encourage you to not talk about what specifically happened on the day.
Tell me I have mail or.
See, this is a good time when having an attorney would be useful to you because you could ask those questions of your attorney.
Okay. So as of now, based on what I told you what happened, is there any way I'll be able to go home, go like to one of my relatives' house today?
So you're welcome to post the bond that I'm about to tell you about, and then you can go home to a relative's house. So this is what the court is going to do. Based upon the facts that are alleged in this case, it's of concern what was presented to the court. And potentially additional charges could be coming from how I heard the testimony. I am going to set a cash bond in this matter. That is going to be $10,000 cash or surety, no 10% privilege. I believe that is appropriate in this case.
Can it be a personal bond?
That's not a personal bond. You would have to post $10,000.
So why is that?
And I am going to require the defendant to have a GPS tether to make sure that he doesn't go back to that address prior
There's
to
no reason to go
release.
back to that address. I never said I wouldn't go back, not go back.
I'm going to have a GPS tether placed on you. They don't place tethers on holidays or weekends, so that tether would not be placed until Tuesday.
I just don't understand why am I being ignored? She has a mental disability.
I'm talking. I'm not sure what's so
I'm
complicated.
not mental health or a drug addict or anything, so why are you guys saying this?
All right, I'm going to mute you if you keep interrupting me. So the tether can't be placed on the holiday or weekend. The tether will be placed on Tuesday. That's the next time the agents are here.
I have work Tuesday. Why you guys want to make me lose my job or something?
I'm not making
Like all
you.
that's necessary. It's the holiday weekend.
So because it's a holiday, if somebody commits a domestic violence, it doesn't count?
If somebody makes a false accusation because I look like one of her exes, it's not up to you guys to do a proper investigation and get more proper information from both of us.
Again, an attorney would be most helpful.
Somebody that doesn't have a mental health condition.
So your bond, hey, I'm not deciding guilt or innocence. I'm just deciding what bond conditions are necessary to keep everybody safe. You've demonstrated to me an inability to control yourself because you keep interrupting me, which is rude and inappropriate in this circumstance. You did it to Ms. Londy as well. So I have to consider your ability to control yourself and follow my court orders. And that gives me concern that you can't do that either. So the bond is going to stay $10,000 cash or surety and a tether prior to release. Ms. Londy, anything further?
No, Your Honor.
All right, you're all set, sir. You can stand up and go to the door. Thank you.
Now this is the time where he should stand up and leave and start planning his pro se motions for bond reduction. Instead, he decides to stick around and make his situation so much worse.
Okay. So there's no way I get to go home unless I pay $10,000.
Right, and get the tether, and you can't get your tether till Tuesday.
So even what if I don't have $10,000 on
Then
Tuesday?
you'll remain in custody until your next court date, which is June 5th at 9 a.m. So that is next week on Thursday.
And that's because I said I wasn't guilty? Well, how, I don't understand.
Of course not.
Yeah,
That has
you
nothing to
said-
do
you
with
said
whether
that
you
I-
said you were
couldn't
guilty
trust
or
me
not. That
because
has to do with,
I spoke out of line, but I didn't raise my voice.
do you want me to answer your
I
question, or do you want to just keep
I didn't say
interrupting me?
anything wrong.
Do you want me to answer your question, or are you just going to keep interrupting?
What am I interrupting? Nothing I said is stopping you from understanding my side of what's going on, or
If
saying
every time I talk, you start
listening
talking
to you
while
or
I'm
being
talking.
disrespectful or nothing. I didn't mean any disrespect towards you or anybody.
Okay, well, here's the thing. The allegations that have been presented,
I understand what you're saying, but I'm not ignoring you. I'm not trying to speak out of line.
then why do you keep talking while I'm talking? We're done. The allegations that were presented to the court give the court concern about the safety for the victim.
What about my
Okay,
safety?
I'm done. We're
And
done.
I told you guys, or
You're
I had
done.
calls
You can
before,
go.
and
You're muted. We're muting you. You've been muted. You can go to the door. You can go to the door. We're all set. I can't hear you. You're muted. So you can stand up and go to the door.
Alright, so that's the end of that video. I wouldn't be surprised if they hold a competency hearing and they rule that he's not mentally fit enough to enjoy his right to self-representation. Not unlike the next guy, who wants everyone in the courtroom, including the judge, court clerk, and even the court reporter, to recuse themselves from his case.
All right, Mr. Vaughn, we're here today because you have filed a number of different motions, and I want to address those motions with you, give you an opportunity to be heard. So if you want to come to the podium, since you are representing yourself, I will deal with each of those motions. First of all, let me advise you that in April of this year, you sent a notice stating it was to the judge of record, stating that on the 15th day of April 2025, I have some concerns that I wish to speak to you about before I file papers in your court. I'm letting you know this isn't a request for advice. It concerns actions by your staff of the courts and yourself. With the utmost respect, I write this ex parte letter. If we can meet in private, I will. If I can't meet in private, I'll file it publicly and the order will be noticed. I could not speak with you privately because of the rules of conduct for judges. So the first notice or first motion that you have filed has been a request for a criminal record, and states that you're requesting the courts to move the state to furnish the defendant with a copy of prior criminal record per Rule 16 of Discovery and Inspection, Rules of Criminal Procedure. If I understand correctly, you're asking for a copy of your criminal record?
Yes, all them requests, the motion discovery is supposed to provide all that anyway, so that'll summing up half the motions. I mistakenly filed them separately.
That's fine.
Some of them.
You're entitled to discovery requests. Here, when you have a lawyer, a lot of times what will happen is the lawyer will be given access to the electronic system that the DA's office has implemented, where all of the discovery information, all of the evidence is loaded into an electronic system that then the defense lawyer can access that defense. Now, you don't have that ability representing yourself. So I'm going to order that all of the evidence in Mr. Vaughn's case needs to be put into written form, hard copies, and he needs to be provided with that.
Judge, the problem with that is going to be that there are videos from his arrest. One of his charges is retaliation for past action. And so there are videos from the officers in the jail at that time. And that's going to be one of the largest problems in providing that to him.
No, sir. That's not a problem. I filed a civil suit years ago. They provided me with the DVD, and that was my issue to deal with after that. And they allowed me to go into the office privately, view my own case, to fight my own case before, so that is not an issue.
Sounds like he's got it solved.
Okay.
You provide him with a DVD or a video on a compact disc. He'll access it as he needs to at the jail.
Okay.
All right, when is this gonna be? Because I've been doing some of this since 2021. I'm tired of coming here looking at y'all. Like, this is going on for a minute. This is getting ridiculous. This is my first, I still ain't got a motion yet.
A motion.
I ain't got a motion yet. All the attorneys I had, all the public defenders I've had, nobody have provided me with nothing yet.
Okay. Well, I'm going to deal with all of that today because you're going to get written discovery. You're going to get a copy of any videos so that you can look at them yourself. How long will it take for him to be allowed? His trial date's in September. How long will it take to get the hard copies of the written discovery? All right. We'll have it within,
Ben, she should have it today.
we'll have it within 10 days. Okay? You have a second motion, which is a motion to remove your counsel. Mr. Spratt was appointed as what is generally referred to as elbow counsel. You want to represent yourself, and I've granted you that opportunity. I've also appointed Mr. Spratt to assist you in representing yourself so that he can, because you don't understand, I assume, the rules of evidence and the rules of criminal procedure fully as if you had been to law school. So having a lawyer who can assist you in making objections to evidence, for example, and things that's the reason that you have elbow counsel. So Mr. Spratt was appointed, and he has tried a number of criminal cases, is very competent as an attorney, and that's the reason. So why do you want to dismiss your elbow counsel or your assistant
For
counsel?
one, the court doesn't respect the fact I'm pro se. They prefer to talk to him instead of to me. And anything should come through me first. He's an assistant.
Well, he's not your assistant. He's there to assist you with any questions you may have regarding the legal process. The prosecution or the courts giving relevant legal items to him instead of you was probably just a formality and a way to ensure you get the paperwork you needed to represent yourself in a more timely manner.
For two, Mr. Spratt, since December, has had a sickness or illness going on, which is on record in Humphreys County Jail, where he never could show up out there. I called 2 or 3 times. I should have had the motion discovery he just handed me.
All right. Well, that's part of life, that people have illnesses and sickness. I am going
Not for a month and a half. I'm sorry, sir. Excuse me, but not for a month and a half. I mean, he ain't able to help me.
Well, I'm of the opinion that Mr. Spratt is able to help you with this because he is only elbow counsel. You're representing yourself. I will order that the discovery and motions that are filed in his court need to be sent directly to Mr. Vaughn rather than a copy to Mr. Spratt directly to Mr. Vaughn so that he gets a copy without having to wait for his co-counsel. No, you just have to mail it to him and he'll receive it. So I'm denying at this time your motion to remove counsel because I think it's important for you to have someone at trial to help you with that. I've ruled you're going to have access to the discovery directly. You're representing yourself. Mr. Spratt's role is as elbow counsel to assist you in, the trial itself.
Well, what about the fact that he couldn't even come to Waverly? How are you going to get to Decatur?
I'm going to appoint Mr. Spratt. You want to address any of that, Mr. Spratt?
I will, Your Honor. I'm not sure of what illness I had for a long time. I was sick back during the holidays. I did just hand Mr. Vaughn his discovery in case number 2021 CR 462. My understanding is the state wishes to proceed to trial in 2022 CR 336. There is no discovery that's been provided to me electronically for that case. When I did finally feel better and go to see Mr. Vaughn, he had been transported to West Tennessee, and I just simply have not been able to make it down there with my schedule. But he does have the discovery, or the written discovery. I did not give him the electronic discovery today because of reasons which he's now clarified.
Well, I told you that too when we talked on the phone. Me and you done been over that.
Let me hear from Mr. Spratt. This is not a time for you and him to discuss.
I mean, I'd be happy to mail him a DVD of anything electronic for that case that I have. I only have discovery for one case.
he needs the discovery for the case he's going to trial on, so let's make sure that that discovery is provided to him. Ms. Bryson says she can provide it to him next week, so I would order that she provide that by mail to Mr. Vaughn next week, as he wants to have it directly, and then a copy to you, Mr. Spratt. All right. I am denying your motion to discharge Mr. Spratt from being your elbow counsel for the reasons I've stated on the record. Another motion you have filed is a demand for speedy trial. Your trial date is in September, which is the next term of court that I have. It's available, and for that reason, I believe that that complies with the request for speedy trial that was filed. It is the first available date that we can put into play according to our rotation of judges and our schedule that we have. That is the first available day. The September date does, in my opinion, comply with your request. Case won't be continued, so we'll need to make sure that it is ready for trial on that day. The remaining motions that you have filed are all motions for discovery, which I think you had mentioned before, and I think we've now addressed that. So he's set for trial on September the 19th, is that correct? That needs to be shown to be first on the docket.
Excuse me, sir.
Docket, so that we'll go to trial. And let me address this. You filed a motion to recuse, notice of recusal or request for the master clerk, and you're asking to recuse or to somehow recuse the clerk of the court, and there is no basis that you have no basis, you have no standing under the law to ask this court to disqualify the clerk of the court. I understand your reasons for why you say that, and I have addressed the problems that you're saying you've had thus far with receiving copies of things, and that's going to be mailed directly to you. The court file will have it reflected that you are to receive all of those as lead counsel in your case, and I am not of the opinion that you have a basis in law or in fact to remove or ask for a recusal of the circuit court clerk, so that motion is denied. In addition to that, you had a motion to recuse the court recorder, and again, I have no idea why you would allege that there is a reason for that, but I don't find any basis for removal or that you have standing to remove the court reporter. She worked for me, and under that basis, I don't find there's any reason.
Well, then me and you have a conflict then, because you was on there doing the same thing they was doing. You want to put this on YouTube and not act a professional? Y'all want to make jokes in here? And then they don't want to file the paperwork? How am I going to get a fair trial here?
You're going to get a fair trial because you're going to be tried according to the law and the facts, and a jury of impartial people who know nothing about your case will make the decision.
So if I want to make an appeal and she ain't recording it, how are we going to do that?
She will be recording it if it is a felony case. There are certain times when the cases are not recorded, or if we're on break, it's not recorded. But
well, we wasn't on break because look, I just walked out the courtroom and I said something after we went on break. You said omitted, and she said, "Well, I ain't got to omit it." She said I wasn't recording no way. So how can I appeal something if y'all taking it out of the record without me being present during the proceedings?
Well, first of all, I don't recall any such thing that.
Well, go back and look at the video.
I'm not required to go back and look at the video, Mr. Vaughn. I'm required to make decisions based upon whether or not you have standing for the motions that you filed. In my opinion, you don't have any standing to ask this court to discharge our court reporter or our clerk. And for that reason, I'm denying those two motions.
Well, recuse yourself because you're not doing it. You're not doing it.
And there's no basis for me to recuse myself.
Is this being recorded?
If you want to file a motion for me to recuse myself, then I will deal with that under Rule 10, and then I will address
I'm familiar with all the rules. Y'all sit me in jail long enough. Best believe I read them.
While you're sitting there, you should really read the warning label on the outside of your jailhouse crayon box regarding the dangers of copious consumption. Now that's the end of that case, as the rest was just a few minutes of formality before they sent him back to his room at the Gray Bar Motel. And now let's head to our final hearing, which is one of the funniest probation revocation videos that I've ever covered, and it comes from a fan favorite judge, Judge O'Donnell.
Right, violation May 15th, positive screen for methamphetamine. You understand that charge?
Yeah, yeah. Sorry.
Mr. Fatica?
Good afternoon, Your Honor. I've discussed this violation with Mr. Davis. I anticipate that he's going to accept responsibility for his misconduct, waive the probable cause hearing and final hearing, and address the violation this afternoon.
Is that what you want to do?
Yes, Your Honor.
What's your plea to the violation?
I'm sorry, I couldn't hear you, sir.
What's your plea to the violation?
Guilty.
All right, I'll accept your guilty plea and find you guilty. So? What's the story?
Just trying to get back to the normal life, sir. I've been working 6 days a week, busting my butt, and taking care of my parents, and I just want to get back to work.
All right, that ain't what I said. That ain't what I asked you. What's the story? You're here for a violation for using again, so what's the story?
I got high again.
Why?
Couldn't tell you. Stupid.
Well, why don't you figure out the answer so you quit coming back here every 3 months?
Yeah, you know,
Where'd you get it?
I really don't know. To be honest with you, I don't know.
What do you mean you don't know?
I don't know where I even ingested it from, but I'm not going to say it wasn't dirty because it was dirty. Obviously, I did take some. It just wasn't like my normally when I do it.
Well, what do you normally do?
Normally, I would smoke some. If I was going to get high, I would smoke.
So how did you happen to get high this time?
I must have either ingested it or eaten it or something, but it was in my system. Doesn't take a lot to be.
You have no idea how that happened?
At this time, no. I've got some guess, but
What's your
I'm
guess?
not denying that it was in my system. I mean, it was in my system, obviously.
What's your guess?
My best guess is this old cooler that I used.
The what?
An old cooler that I used to keep drugs in and stuff like that. I used it a couple of days for work, and then I actually just got a new cooler.
Well, have you soaked that cooler in drugs yet there, Chief? Because something tells me that your drugs in the cooler story is just a bunch of bullshit for so many different reasons, and Judge O'Donnell isn't buying it either.
I know it sounds crazy.
What was in the cooler?
At the time, I thought nothing, but
Well, I know, you said you had something in the cooler. What was in the cooler?
well, I just threw a bunch of food in it in the morning and some pops and stuff for the day, and went about my day. So it could have been something in the cooler that leftovers from when I was partying. But I'm not saying I didn't do it.
You don't expect me to buy that line of bullshit, do you?
Just
Do you? Do you really?
No, I'm just telling you that's all I know. I didn't
Okay.
go out and smoke
Oh,
meth.
God almighty.
I didn't buy any, I didn't get any, I didn't have it and smoke it. I promise you that. I'm not trying to make it up. Last time I told you I did it, when I did it, I got it from a guy at the IOP. And the time before that, I got it from somebody at work, and I was doing it.
I've never heard that one before. It came out of the cooler.
No, I did it.
I know you
It's in my
did.
system.
Okay, you just don't want to tell me how you did it.
I didn't smoke it, I must have ingested it. So I ate some, I'll say. I know how it sounds crazy, and I know it sounds like BS, but I don't know what else to tell you. I didn't smoke it intentionally or anything like that, like I normally would. I am trying to get back to a normal life,
You've been in the old life.
and I'm working very hard.
Well, you're coming back here every 3 months for,
I understand.
so what effect did it have on you?
What, the court, or, I mean, the jail time, or that, actually, I couldn't tell you, because I didn't really feel the effect. It used to get me amped up and feeling good.
Come on now.
What do you mean by what effect? I'm not understanding the question, sir.
When you were here a few months ago
Mm-hmm.
and you smoked, what effect did that have on your perception, on your, on what you were thinking,
I was
your
actually,
actions?
I was actually upset with myself and
No,
felt,
no. I mean, when you smoked them, did you get high?
yes, I used to, yeah.
So what did you do when you were, how did you feel when you were high?
Just energetic and good. I mean, the last time I did it, when I smoked it, I felt like crap. I felt depressed, I felt ashamed. And that was the first time I'd ever felt shame in my life over doing something that I used to do just for fun, you know? But I did feel shame last time I smoked it.
Okay, when you had the after effects of the cooler, was the feeling the same?
No, because I really didn't feel it.
So you didn't get high at all?
Mm-mm. Not any kind of substantial high, no. That I remember, anyway.
What kind of cooler was it?
Just one of those, like, igloo coolers with it was a bag with like a liner in it.
So in what form did you use to put your, in the igloo
It
cooler?
had the front zipper part. I'd keep some, whenever I was doing drugs, I always had a cooler with me.
In
at
what, a
some point.
liquid form or powder
No,
form?
it was in powder or crystals or whatever, little chunks. But I would always throw stuff in there, in the little zipper part. There's a zipper part in the front to stay dry. That's where I keep cigarettes,
So when
stuff
you,
like that.
when you had the food in there this time, in the,
I didn't think anything of it. I just.
well, I know, where did you put that? In the zipper part or in the
Yeah,
cooler
I
part?
threw a couple sandwiches in the zipper part and threw some ice and a couple Pepsis in the cooler part.
Why didn't you put the sandwiches in the cooler part to keep them?
Because then they get soggy. I mean, I only used it for a couple of days because I needed to get a new cooler anyway. It was an old cooler. I just needed something for those couple of days to get through the day because it was warm days. I wanted some pops I was going to be gone all day.
How big is the zipper container?
It's big enough to hold a couple sandwiches and some cigarettes.
You can't make this shit up. He literally just described the size of the pocket as big enough to hold 2 sandwiches and some cigarettes. Keep in mind, his sandwiches aren't wrapped in any sort of protection because that's how he accidentally ate the drugs. And he didn't refer to his cigarettes as a pack, so those are probably just rolling around in the bologna and mayonnaise as he pulls them out one at a time 3 times before lunch.
It's so cool. It's like a bag
I
cooler.
mean, the more this conversation goes on, the less I believe it. I didn't believe it from the start.
I don't know what else to say.
So you're a guy that, once again, you're how old now, 53?
53.
53. You didn't start using drugs till you were 47.
When I lost my everything, yeah. I went down
At
the
least as far as the record shows, which is
Right.
probably a good bet. Okay?
No, I mean,
And then-
that was when I started, when I got divorced and my wife left me after 22 years.
I know, but
spiraled out of control.
it's probably not a situation like you were using since you were 20 until
No, I
and
really
all of a
wasn't.
sudden you got caught at 47. You probably weren't using, otherwise, because you ain't very good at this stuff.
No, I'm terrible at it. I'm the worst criminal.
So you get 4 convictions, all in 19, all in December of 19.
Yeah.
Then you get nothing until February of 24.
Yeah, I'm not very good at this
And
criminal.
so what kind of drugs was that in February of 24?
It was everything was.
Okay, so then you get sentenced on that in September of 24. Then you got a violation, you're here again in, 2 weeks later? Is that what that was, Dave? Like 2 weeks?
The first one, yeah.
Yeah, he was sent September
18th, right?
And we filed on him October 3rd.
And when was the use from?
He had tested positive
From,
first time on a sample he submitted on September 23rd.
okay, so 5 days after you're sentenced. And then, you come back in November 20th, and I keep you on probation, you did 52 days in jail. So you get out, and then when's the, on the next affidavit, when was the date of the positive test?
That one was submitted on January 16th.
January 16th, so about 9 weeks later, after you get out of jail, you're doing it again. So February 19th, we'll get that one cleared up. And 3 months later, you're doing it again. Although you're not really doing it again, right? So, what am I supposed to do with you, who just won't quit doing what you're not supposed to do?
Just want to go back to work, sir.
Just want to go back to work.
Just want to work and get my life back.
This is the fourth time I've heard that from you. You just want to get back to work.
I'm working though. I am working.
Yeah, but then you're using two.
I understand.
You're working and using, working and using, working and using,
I understand.
and you're in jail.
I understand.
How long have you been sitting in jail this time?
Since Thursday.
So, did you go to that Rosary Hall IOP a long time ago?
Yes, sir.
2 violations ago?
That's when I got violated coming home with, that's when I got high coming home with somebody from there. But I'd be definitely willing to give any IOP another shot. I would love to.
Why? If you just, it was all by accident, why would you need treatment?
I don't know what to say.
You got any suggestions here, Mr. Fatika? Because this is a mystery.
Your Honor, he's been consistent with me. He just wants to get.
I know he has. He's been consistent here, but he's been consistently lying since I've been in here. So, is this a guy who needs treatment or doesn't need treatment? Because he really hasn't consciously done any since November. So he's been free except for the cooler for 8 months, 7 months. So what's the point?
I don't know which one to say, sir.
I don't know. Say anything you want to say, okay? But, you know, blaming it on the cooler ain't working.
No, I know.
So you got a problem or don't you got a problem?
I mean, I guess I have a problem.
Okay, you guess. So going back to work isn't going to cure the problem because you were going to work and using, right?
Well, I mean, I think I'm able to kick this. I know I am.
No, you're.
I just need to stay busy, and that's what I've been doing. I know it didn't work, but whatever. I'd like another shot to at least prove to myself that I can do this. I'm going to AA. I go to 4 meetings a week of AA. I've been doing that religiously. I got a home group. I enjoy those meetings.
Well, what good are they doing?
They're keeping me focused. I'm a good man, sir. I've had some problems, and
I'm not opining on whether you're a good man or a bad man, okay? I'm saying you got a problem that you don't think you have, okay? Because you've only done it like 3 or 4 times, okay? But you didn't do it this time, okay? And you're telling me all you gotta do is work and stay busy, but you were working and staying busy and still getting high. So that's not accurate either. So it's got nothing nothing to do with you being a good man or a bad man, okay? I'll accept the fact that you're a good man because the only trouble you have is 8 days in December of 19 and this shit that started up last fall. That's the only problems you've had. So the problem, the question becomes, how do we keep Brian Stavis from coming back here every 3 months? And it ain't by just going to work and staying busy,
I understand,
because it ain't working.
I understand. I mean, I've done NeoCap, I've done all that stuff, which that did help. I mean, I got 2 years clean after that, but I relapsed and, I mean, if there's a treatment you want me to do, I mean, I guess we'll give it a shot. We're looking, I've got a lot of open work to do that I really need to get to, but I mean,
Yeah, well,
I got cabinets, I got a whole woman's kitchen in my garage, getting the
Yeah.
cabinets redone.
Jesus. Then
Nothing I can do about
you
it.
shouldn't be out there smoking.
I get that, I get it.
Where were you going to AA meetings?
I go to a meeting on Wednesday night is at a First Presbyterian Church on Route 91 in Mayfield, or Highland Heights. And I go to, my other one is at, there's two at Lyndhurst, First Baptist Church.
Who's your
One's a
sponsor?
Sunday and then one's a Saturday. What's that?
You got a sponsor?
I do not have a sponsor yet, no, but I do have a home
Why
group.
not?
I just haven't found the right person yet.
What, well,
I mean, I'll get
I
one.
mean, were you looking at all because
Yeah,
you were?
originally I had one, but he just didn't, he's not going to the same meetings as I go to all the time, and he doesn't, I haven't seen him in a while, so I just kind of didn't even mess with him. But I mean, I've been looking at one guy I've been talking to, I'm gonna probably end up making him my sponsor, he's in my home group.
You sound like the kind of guy that's gonna do, and you don't do.
No, I actually have, man, I go four meetings a week, so, and I've been enjoying it. My home group is one of my favorite nights of the week. It's Wednesday night. It's a good meeting. It's open book, a lot of conversation. And the guy I've been talking to that I think is gonna be, been sober for 40 years, so. And he's sponsored a lot of people, so hopefully he's willing to take me on. And
I guess at this point, we need to ask him, what flavor cooler does this potential sponsor like to use?
I know it doesn't seem like it, but I do want to be sober, sir. I want to stay clean. I want to get my life back. I really do.
I would assume so,
I really do.
since you keep ending up in jail.
I promised myself last time that I was never going to be in these again, and I failed. And I let myself down on that, and I don't ever intend on doing it again.
Okay. I would guess that 95% of the people that walk out of here at the end of the hearing never intend on doing this again.
I know. I
And
get it.
of those, probably 90% come back having done it again.
I understand. And I'm one of
So
them.
just wanting to not do it again doesn't mean you're not gonna do it again.
I understand.
So it seems to me that these meetings haven't done you a lick of good because you're not utilizing whatever you're supposed to get from them. And you didn't get a sponsor because you just didn't see fit to get a sponsor. That's why you didn't get a sponsor.
Well, I mean, you have to, the program is 12 steps. I'm just starting out. I'm going on the steps. I wanted to get some meetings in. I've talked to people. I've been going. I've been doing extra stuff with them. Just wasn't ready to get a sponsor.
Everything you're doing is right on the surface.
Yeah.
The people who are on the surface keep coming back. The
Well,
people
that's
who
what
dig, trying to figure out why they're doing what they're doing, are the ones that are less likely to come back.
I get it. I get it.
I mean, your whole thing now, for the fourth time, is you just want to get out, go to work. That's what you want to do.
But I want
This
to
is the fourth time we've had the same conversation now.
I want to have the program. I want to let the program sink in. I want to get in. I want to submit. I want to surrender myself to the whole program. And I plan on doing. That's what I'm doing. That's my goal.
Okay, that may be, that may sound good, but you coming in here and telling me that you got them from the sandwich in the cooler.
Listen, I
Tell-
understand, no matter what I say, I understand, doesn't sound right, doesn't sound good, and there's nothing I can say that's gonna change your mind, so I mean,
Oh, yes, there is. It's called the truth. Judge O'Donnell might be crazy, but he's also sympathetic, and he helps out people who are truly remorseful and tell the truth. He also sends people to jail who tell him a bullshit story like it was my cooler's fault. So let's hear what his sentence is gonna be.
Where's the cooler right now?
garbage, I threw it away.
Huh?
I threw it away when I bought a new cooler. I needed a new cooler anyway. That thing was old and beat up. I just used it for a couple of days just to get by till I got my paycheck. And then bought a new cooler and some extra clothes and another pair of boots.
All right, you're gonna stay on community control. You're gonna serve 50 days with credit for 5. You're gonna get into the jail treatment program at the earliest date possible. Dave, make sure that we check on that, okay?
Yes, sir.
And then follow all the recommendations. If you get in earlier than the 45, then the rest of the time will be suspended. Go into at least 4 AA meetings a week and get a sponsor.
Gotcha.
Stop with the process of getting a sponsor, and let's go with getting a sponsor.
Okay.
Maintain full employment. Dave, anything else?
No, sir.
If you don't get honest with yourself, you're gonna keep coming back here. And eventually, you're not gonna come back here,
I get it.
because if you don't get straight with yourself, then there's only one thing left to do. Anything else, Mr. Fatico?
No, thank you, Your Honor.
Thank you, Your Honor. I appreciate it.
Alright guys, that's the end of today's video. Each of these cases, except the last one, should have a follow-up in a future video, and given the interesting nature of each case, I'll be sure to bring you the results. Don't forget to head over to Coolin McCollin's channel and give him a sub. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.